Right, hello again everyone. Thanks for joining us for this session on tackling money laundering, getting it right for your firm. Now, it is tempting, I think, to see anti-money laundering as a rather dry subject, very much about complying with a suite of regulations. But it is important not to lose sight of why this all matters. In my line of work, I'm often reporting on crime and terrorism, some of which is funded by the washing of dirty money. And it's not a victimless crime either. Money laundering can eventually ruin lives, even destabilize whole countries. The ill-gotten gains of people trafficking, drug smuggling, or terrorism can have devastating effects. One man has already been charged just this week in connection with the deaths of 39 people found in the back of a refrigerated lorry in Essex. Many were Vietnamese people being trafficked. And in recent months, I've been working on reports on the devastating effects of knife crime. Some of those involved are gang members selling drugs. Their money is often rinsed, sometimes through the unsuspecting bank accounts of college students. So, we all know it's a big problem. No country or region is immune from the risk, and solicitors have a real opportunity to make a difference by making sure they're at the forefront of efforts to prevent money laundering. So I'm delighted to introduce our speakers today who are going to share their insights. Colette Best leads on this at the SRA with more than a decade's direct experience in the legal, housing and financial services sector. Mark Boyle has recently joined the SRA's new anti-money laundering team and was previously in a management role at the Royal Institute of Chartered Surveyors. Mark also has experience in international trade and textiles. And joining us for our Q&A session a little bit later on will be Zoe Allen Robinson, a qualified solicitor who's worked in private practice in criminal and public law before joining the SRA. Please do think of questions that you may want to put to our panel now. Get your juices going. Get thinking about what you might want clarified. But first, let's hear from Colette Best.
Good morning, and thank you very much for choosing to come to our session on anti-money laundering this morning. I think it's a really important topic, but as Director of Anti-Money Laundering SRA, obviously I would think that. So the format of the session for this morning, in true SRA style, we're already running about 5 minutes late, but we'll try and get you through to lunch for around 12:20. So the way this session will run is I'm going to speak a little bit about the requirements in the regulations and how firms are getting on. And then I'm going to hand over to my colleague Mark, who's going to talk a little bit about the changes which are heading our way in the near future. And then finally, we should have about 20 or 15 or 20 minutes or so for questions. So I'm joined by my colleague Zoe, whose team has just read through 400 firms' anti-money laundering risk assessments. So there's nothing that she doesn't know about good and poor practice in this area. And if you don't get a chance to ask a question during this session, please come and visit us at the AML stand. We're in Hall 3 all day, and there's lots of people there who will be on hand to answer any questions. So let's kick off with why anti-money laundering is such a priority topic for us at the SRA. So the National Organised Crime Agency has said recently that organised crime is chronic and corrosive to the UK. And they say that organised crime kills more people per year than terrorism, war and natural disasters combined. And what we know is this, that organised crime is costing us in the UK £37 billion per year. So it's a massive impact on our economy. There are around 4,500 organised crime groups operating in the UK, and around 181,000 offenders linked to organised crime. And what we know is this, so most drug dealers view prison time as a part of doing business. That's not a deterrent to them. But what is a deterrent is not being able to launder the profits of their crimes. So that's the best way to deter organised crime. And it's up to you guys as gatekeepers to financial services and property to be on the front line of stopping crimes such as drug dealing, human trafficking, corruption and illegal arms dealing. So that's one very good reason. Here's another. So the SRA, as a legal services regulator, we care deeply about the reputation of the legal services sector and protecting the integrity of the profession. There's been several quite high-profile scandals over the past few years, so thinking about the Panama Papers, the Paradise Papers. Just last week, Transparency International published a dossier on links of professionals to money laundering. And so what we know is this, that fundamentally the vast majority of people want to do the right thing in stopping organised crime. Clearly you guys all do because you're here and you've chosen this session today. But this is an area where a really small minority can have a massive impact on the majority's reputation. And another reason that we care very deeply about this is actually because we have to. So we are a designated anti-money laundering supervisor under the anti-money laundering regulations. We're actually the largest anti-money laundering professional body supervisor. Around 2/3 of firms that we supervise fall within scope of the regulations, so that's just under 7,000. And we ourselves have an oversight supervisor, that's OPBAS, the Office of Professional Body Anti-Money Laundering Supervision. And our oversight supervisors set standards for us that we have to comply with. And they set that out through their own handbook. And we have regular checks and visits ourselves into how we're supervising this area. So any gaps in how we're supervising, we have to correct. So that's the why. Let me move to talk briefly about what exactly you need to know. So the most important piece of legislation to be aware of is the money laundering, terrorist financing and transfer of funds information on the payer regulations 2017. We refer to them as the money laundering regulations. So the money laundering regulations set out requirements on those acting as gatekeepers to services that could be used to launder money. So for you guys in the legal services sector, that's predominantly conveyancing and facilitating transactions in property, but also dealing with companies and forming trusts. So one of the most important things to be aware of, and something that we've had a few questions on the stand this morning, is actually whether or not you're in scope of the money laundering regulations. As I said, around 2/3 of firms are in scope, but that leaves 1/3 of firms that aren't in scope. So those firms are typically those doing things like employment law, for example, that isn't transactional. That said, the money laundering regulations do enshrine a risk-based approach, so if you're not in scope, there might be certain bits of the regulations that you might still want to put in place to protect your business. So if you are in scope of the money laundering regulations, you will have to nominate certain individuals within your firm. So the two main ones are the money laundering reporting officer. So this is the person within your firm who will receive internal reports of suspicious activity, and if necessary, will be making reports to the National Crime Agency. Another role that's really important is to have a nominated money laundering compliance officer. So this was a new role that came in when the 4th money laundering directive was brought in 2017. And this is intended to be a senior person within your organisation that ultimately has responsible for making sure that your firm complies with the regulations. So it's really important that you have those two roles and that you've nominated them and informed us at the SRA of who they are. The regulations don't stop at just those two designated roles. They also set out a number of positions of significant control within the organisation. So they talk about beneficial owners, officers and managers. So all the beneficial owners, officers and managers within your firm will have to be approved by us as your AML supervisor. So you need to make sure that you've identified who those individuals are and that you've nominated them to us and that we've approved them. There will be some changes to that approvals process when new regulations come into force, we think on the 10th of January of next year. And my colleague Mark is going to talk about that in a little more detail in a moment. So a few more things from the 2017 money laundering regulations that are really important. I've spoken a bit about the risk-based approach, and the risk-based approach is really enshrined in anti-money laundering regulations. It flows all the way from the Financial Action Task Force, where these standards first originate from, right through the European directives, to the UK legislation, to the way that we supervise, and then to your firm. So you need to be directing your resources to the highest areas of risk. And to do that, you need to have a firm-wide risk assessment in place and to also assess the risk of each client or matter. I'm going to speak a bit more about the firm-wide risk assessment in a minute. And then once you've assessed your risk, the next stage of your process is to make sure that you have really robust and written down policies, procedures and controls to mitigate your risk. The next step following on from that is that you can have the best policies, procedures and controls in the world, but they're absolutely no good if your staff don't know what they are. So it's really important to make sure that you train your staff and that everyone is aware of what they need to do. You also need to document that training, and that's so that if we come and check those training records, that you have a record of that. And then the other main requirement in the money laundering regulations is to do risk-based customer due diligence and to keep records of those decisions. So knowing your customer is a really important bedrock of the money laundering regulations. And again, the risk-based approach flows through to this. So you need to know what level of risk your client poses, and you need to do customer due diligence that's appropriate to that. So, for example, one high-risk area is dealing with politically exposed persons, and for them, you need to be doing enhanced due diligence, EDD, which might involve things like obtaining more information and getting senior management sign-off for dealing with those clients. And then once you've initially identified your customer, something that's really important is to do ongoing customer due diligence. And this is so if you have an ongoing transaction, if something changes in relation to that client throughout the transaction, you're in a good place to pick it up and notice if anything is suspicious or if your firm is being used to launder money. The other important piece of information, piece of legislation to know is POCA, Prices of Crime Act 2002. Bits of POCA apply to everyone, but there are additional parts that apply to those just within the regulated sector. So the Prices of Crime Act sets out the underlying offences of money laundering. So it essentially says that you can't handle or convert or control criminal property. And then for the regulated sector, there are additional requirements. So you need to know what the warning signs of money laundering are, and you need to make sure that you have a process in place to make sure your staff know how to identify suspicious activity, who to report it to internally, and you need to make sure that you have policies for your money laundering reporting officer to make a SAR, a suspicious activity report, to the National Crime Agency where there is a suspicion of money laundering. That said, you can report suspicions of money laundering even if you're not within the regulated sector, and in fact we very much encourage you to do so. The National Crime Agency say that the intelligence contained within suspicious activity reports is absolutely crucial to the fight against organised crime, so would really encourage you to be submitting suspicious activity reports. So how are firms getting on in complying with the regulations? So this is an area where we do both proactive and reactive supervision. So in terms of reactive, we do a lot of responding to complaints, as you might imagine. And that can include whistleblowing and other information that has come to us from the firms direct. We also share a lot of information with other supervisors, with law enforcement, with the National Crime Agency, and other regulators in the sector. In this area, we're also rolling out a programme of proactive supervision. We already do some of this, and we'll be building on that programme over the next few years. But as you know, we have a programme to call in firm-wide risk assessments. We do thematic reviews, and we actually have a programme of visits in place to go out and visit firms. So typically we have around 200 anti-money laundering files at various stages of the process in the organisation. And so what we've seen from both the thematic reviews, our visits and our risk assessment exercise is that firms are still struggling to comply with certain aspects of the regulations. And there are three kind of main trends that we've seen from our activities. One is problem with the firm-wide risk assessment, so I'm going to come on and talk to that a little bit in a moment. Another big theme seems to be dealing with politically exposed persons. I've mentioned PEPs, politically exposed persons, earlier. In 2017, the definition of politically exposed persons was extended, so they now include persons within the UK. And someone within our team did a kind of back of an envelope calculation recently and worked out that there's around 39,000 PEPs that you could potentially be dealing with. And firms seem to be struggling in two areas. One is that they don't have a policy, firstly, to identify if they're dealing with a PEP in the first place. And secondly, they don't have a policy to know what to do if they do come across one. And we've seen some firms saying that we'll simply turn PEPs away, which isn't really the point of the regulations. So long as your risk is mitigated, there's absolutely nothing to say that you can't be dealing with politically exposed persons. And then another trend we're seeing, which is quite interesting, is that we're seeing firms with absolutely fantastic policies, procedures and controls in place on paper, but when we come to do file reviews, those don't actually make it into what's actually happening in practice. So I guess this goes back to what I was saying about training and making sure that if you've got good policies and procedures and controls, that you're actually using them in practice. So let me come on to talk about the firm-wide risk assessment. So I've spoken about this earlier. You may have seen that we put out quite a lot of information about this yesterday. Let me start by talking about the exercise we did in this area. So in spring of this year, we called in 400 firms anti-money laundering firm-wide risk assessments. And what we found was that around 1 in 5 weren't complying with the regulations. And there were two main reasons. Around 10% sent us something that actually wasn't a firm-wide risk assessment. So we saw, for example, training manuals, we saw some policies, and around another 10% missed off a required piece of information. So I'll go on to talk about the information that you're required to include in a minute, but it's things like your client risk, your transaction risk, and if you're not covering all of those factors, you're potentially missing off a really important risk area. Some of the quite interesting things that we saw was that 135 had a creation date that came out of the date of our request. So that's not conclusive, but it does imply that some firms may have not had one in place until they received the letter for us calling it in. This requirement has been in place since June of 2017, so we would expect all firms by now to have a written firm-wide risk assessment in place. Something else that was quite interesting was the use of templates. So we saw a lot of firms using templates. Nothing inherently wrong with that, but what we did find was that where firms were using templates, a lot of them were looking suspiciously similar. So there are a lot of bits of text that we saw in multiple different firm-wide risk assessments. So if you are using templates, you need to make sure that you're using it in a kind of considered and thoughtful manner, and that you're adopting it and adapting it to your firm. So off the back of this exercise, you may have seen yesterday that we've published quite a bit of information. We already had some information out there, so we have already published a sectoral risk assessment, which is where we set out the areas that we think are high risk in the legal services sector. There's also approved legal sector guidance. But yesterday, we also published a specific piece of guidance on creating a firm-wide risk assessment. And this sets out some of the things that we've seen throughout the course of our exercise. And we've published 2 practical documents that will help you to put in place a firm-wide risk assessment or improve your firm-wide risk assessment. So we've published a checklist, which is intended to be a document that you go through while you are creating your firm-wide risk assessment or adapting your firm-wide risk assessment. And we've also published a template, which is by no means mandatory, but we think is a good starting point for setting out the risk factors to your firm. And as you heard Paul say this morning, this is obviously an area that we're seeing quite high levels of non-compliance. So we will be really stepping up our monitoring activities in this area. So we'll be continuing to call in more firm-wide risk assessments, and we'll be writing out to all firms in scope to ask whether they have got one in place. So, supposing you do get that call, what exactly are we looking for in a firm-wide risk assessment? So I've spoken about the risk-based approach, and this is how you set out what the risk factors are to your firm. So essentially, we're looking to a kind of a considered and thoughtful approach to identifying risk in your firm. The one that we saw, which was an email which says there's no money laundering risk to my firm, consider this of my risk assessment, isn't really going to cut it. What we are looking for is a document that reflects on who your typical client is, and it should think about the risk inherent in the services you provide, and it should consider how exactly you deliver your services and the geographical areas that you operate in and where your clients come from. Some of the indicators of poor practice that we saw was risk assessments not written down. So essentially, if it's in the eyes of the regulations, if it's not written down, it doesn't exist. It has to be a written document. And some of the risk assessments we saw looked quite out of date. They might have referred to old regulations. So it should be a living document, your risk assessment, so it's important to make sure that you're reviewing it regularly and updating it if necessary. I've spoken a little bit about templates previously. I have to say that some of the best examples of risk assessments we saw were quite often by small firms that hadn't used a template risk assessment. And we think that's because they were kind of required to think about the requirement from scratch and to really consider what the risks to their firms were. Some things to consider as well, if you are using templates, not to rely on standardised text. We do see a lot of these now, and we do spot where things are just copied and pasted across. And there's lots of documents out there which are useful in creating your risk assessment, but actually there's some that are required to be considered, and that's set out in the money laundering regulations. So you need to consider the national risk assessment and our sectoral risk assessment that we've published, and we saw some examples of people not considering those. So I mentioned this earlier, so these are the 5 areas that are set out in the money laundering regulations that your firm-wide risk assessment has to consider. So product and services risk, your client risk, transaction risk, delivery channel risk, and geographical risk. I mentioned our sectoral risk assessment earlier. If you download that document, that sets out our opinion on which of the high-risk areas are in each of these categories. So it's a really useful document for you to see how many of those apply to your firm. So some questions that you might want to ask yourself when you're completing your risk assessment under each of those categories. So when you're looking at your product and services risk, so do you do high-risk work? And typically that is going to be conveyancing, trust and company formation. And we also see very high risks associated through operating a client account because we know those can be a target for money launderers. Something that we saw when we did the exercise is that some people creating the firm-wide risk assessment actually went round the heads of department to speak with people about what the different levels of risk were for each of those departments, and we thought that was quite a nice idea. So in terms of client risk, a lot of this is about understanding who your typical client is. So what is the nature of his or her business? Do they come from perhaps a high risk or a high cash intensity business? Can you effectively screen for politically exposed persons? I mentioned politically exposed persons earlier. It's really important that you know if you're dealing with them. Who actually owns and controls your clients? Where did they get their money from? And do you have robust means of actually identifying them? So in terms of transaction risks, some things to ask yourself is where did the money come from the transaction? Again, just sort of taking a considered approach. Where is it likely to be going to? And consider how large or frequent your typical transaction is likely to be. Then looking at delivery channel risk. So this is all about how you deliver services to your clients. So have you seen them face to face? And if you haven't, how can you be sure of who they are? Is there a risk of someone coming into a non-regulated part of your business and then passporting over to an area that is within scope of the regulations and therefore circumventing customer due diligence checks? That's something that's really important to be aware of. And then finally, in terms of geographical risk, this is kind of twofold. So what is the area that you operate in, but also where do your clients come from? So some good lists to check is the FATF, the Financial Action Task Force Index, the Transparency International list, and the Basel Index. So what are we getting up to over the next year or so? So clearly this is a top priority for us. That absolutely isn't going away in the year ahead. Preventing money laundering is going to remain a really important priority for us for the year ahead. And actually, we continue to view failure to prevent money laundering as one of the biggest risks to, well, us as a supervisor, you guys as firms, but also the country as a whole. As well as general compliance with the regulations, there's two big areas that we're going to be focusing on over the next year or so. One will come as no surprise, the firm-wide risk assessment. It's an area where we're seeing lots of non-compliance. It's a really important document. It isn't just a tick box approach. It's how you enshrine your risk-based approach to dealing with anti-money laundering, preventing criminals from using your firm. And then the other big area is, as Mark is about to speak about, we're going to be seeing more new regulations coming into force. So the 5th Anti-Money Laundering Directive will be transposed into UK legislation. We think on the 10th of January of next year, so quite soon we'll be having new changes. It will mean some changes for how we do business. It will mean some changes for you. So we'll be very much focused on that over the year ahead. We're also, as I mentioned earlier, stepping up our proactive supervision in this area. So that includes things like thematic work, but also more visits out to firms. So the chances of us coming and looking at your anti-money laundering policies, procedures and controls is increasing year on year, I'd say. And we're also prioritising the cases we see through a dedicated team. So we do now have specialist caseworkers dealing with anti-money laundering issues. So I'm going to hand over to Mark now to talk a little bit about what changes are coming your way, but hopefully we'll have a chance for questions towards the end, but also come visit us on the stand. Thank you.
So thank you. I'm going to talk about some changes that have recently come in, some changes that we need to be thinking about right now, and then I'll address some changes that are a little bit further out in terms of time scope. So the first thing I'm going to address is the Economic Crime Plan. Now this was introduced in 2019, in July 2019, and it is a very broad and very ambitious document which sets out 52 separate actions. And the implementation of these actions is a collective responsibility of a wide range of organizations, from different government departments, Home Office, Treasury, etc., to crime agencies like the National Crime Agency, and to AML supervisors such as ourselves. Now, in terms of how those 52 actions are organized, there is a set of headings that I'll list out that gives you an idea of the breadth of issues that these actions are intended to tackle. So, threat and performance metrics, information sharing, powers and tools, enhanced capabilities, risk-based supervision, transparency, and international strategy. So in terms of what the economic crime plan may mean for yourselves and what it may look like, I think there's a few things that are worth drawing out and highlighting. The first is that we will be, as a part of a collection of other legal sector supervisors, providing input into threat assessments. So using our position and using our vantage point over the profession to be able to feed in the things that we see and the issues that we encounter into wider scale assessments of actually where are the threats from an anti-money laundering perspective. The converse of that, in a way, is that we will also be able to use our position to then disseminate information outward to the profession. Some of the valuable products of this information sharing will then be shared out from ourselves and the other legal sector supervisors. The other thing I'll mention with regards to the economic crime plan is something that potentially, and in some ways I hope you're already familiar with, and it comes down to disclosures made to the National Crime Agency around suspicious activity. In the lingo, we refer to these as suspicious activity reports, or SARS, to use the acronym. Now, if you're familiar with submitting suspicious activity reports to the National Crime Agency, you may be familiar with the portal that is used to make those submissions. And I don't think it's going out on a limb to say that many would regard it as maybe not the most ergonomic user experience in the world. I think the platform was created some time ago, and I think by and large everyone recognizes that it is in need of update. And I think also referring to the point Colette made about the value to law enforcement and to the National Crime Agency that comes from these disclosures, to make sure that they are done in the best quality possible to allow law enforcement to utilize them to understand actually what's happening out in the real world. I think that's reflected in the prioritization of this update to the portal. So that's a tangible change that is coming in the not too distant future. So moving on, I think the next big change is the 5th Money Laundering Directive and its transposition into UK law. When thinking about these rounds of regulations, I think it's probably fair to characterize the last round as quite a dramatic change, the regulations in 2017. I think there were some fundamental shifts that required changes to how firms comply with those regulations. With regards to the new set of regulations, which are due to be implemented by the 10th of January 2020, I would say that for the most part, it is more so clarification and update rather than necessarily massive fundamental changes. Now, there's a few exceptions to that, and I will pull out a few examples. But by and large, I think it is more clarification rather than revolution. So the first big change is that firms will have a duty to report discrepancies in beneficial ownership information to Companies House. Now, however you come across these discrepancies in information, whether it's through information submitted to yourself as a part of your due diligence, or whether as a part of your verification of the information submitted to you, the duty will be the same. You will still need to report discrepancies that you find to Companies House. Now, Companies House, as is, does have a portal through which you can do that, essentially, notify us if there's anything wrong with this page, something along those lines. But it's also worth noting that the relevant government departments are actually looking at the role of Companies House and looking at updating it and, I would say, evolving it. In many respects, if you have read much around Companies House, or if you've spent much time on there yourself, you might have noticed that in many respects, the quality of the information there is not what it could be and not what everyone would like it to be. And I think a lot of those reforms with regards to Companies House will be aimed at addressing that issue. But just to flag that in terms of the number of discrepancies, particularly in the initial stages, it could be a significant number of discrepancies reported to Companies House. The next thing I'll mention is around trust registration. Now, there's already a requirement in some types of trust to register them, to report them to HMRC. Now, by and large, without getting into the specifics of it, I would say that that requirement will expand. The number and type of trusts that will be brought into these requirements is due to expand from the 10th of January. And while we mightn't be able to say exactly at this point in time the full breadth of types of trusts that will be brought into it, if you look back at the consultation paper that was released in the first half of this year, it would be fair to expect those trusts that perhaps do not have a UK tax consequence being brought in some regard to the requirement to register with HMRC. With regards timelines and deadlines for that requirement to register, if a trust exists before the 10th of March 2020, there will be about a year within which to register that trust, but beyond that date, the time frame within which you need to register will actually be much clearer. It will be 30 days from when the trust was created. So the last thing I'm going to mention is a relatively small change within the regulations themselves, but that actually has an impact on how we supervise yourselves for anti-money laundering. So one of the ways in which we have approved individuals, and those individuals are beneficial owners, officers, and managers. One of the ways we've done that is that we have essentially relied on the requirement that those professionals have to report to us if they're subject to any relevant convictions. And if you're subject to convictions under the regulations, there's a specific list of relevant convictions. If you're subject to those convictions, then you're prohibited from serving as a beneficial owner, officer, and manager. In the past, we've relied on the professional obligation to report that to us to assure ourselves that the person who's applying is not subject to these convictions and therefore can be approved. In the future, we will not be able to make that assumption. So at the point of application for beneficial owners, officers, and managers in the future, we will require a basic DBS check to check the criminal background of any individual who is applying to us under the AML regulations. Just one point to really note in that, these are not going to be a retrospective requirement from our perspective. So for all of those previously registered beneficial owners, officers, managers at existing firms, they will not need to re-register necessarily with ourselves. This will be a requirement for new registrants. So those are the main points for the regulations that are coming in the near term. And I think that it's worthwhile then looking into, frankly, not too distant future to what comes after the transposition of the 5th Money Laundering Directive. Obviously, it is the 6th Money Laundering Directive. And I think the focus of that is fair to say, again, looking back to 2017 regulations was a revolution. 2020, the new regulations coming in, perhaps an evolution. I think the focus for the next set of regulations is specifically on criminality in many regards. So the first thing to mention is that there will be a definition of money laundering offences. Now, it's worthwhile contextualizing that across the various jurisdictions of the EU, that I think the view of the Commission was that there was not an equivalent application of what are relevant criminal convictions in terms of the transposition of money laundering regulations. That's to say that not all jurisdictions were treating this in the same way. And I think that the Commission, arguably maybe frustrated with this, was decided in the next directive to actually standardize that list, to set a minimum. Now, I think in some ways, this may not necessarily have a huge impact on the UK, and that's leaving Brexit to one side, of course. I think that because of the existence of legislation in the UK, particularly the Proceeds of Crime Act 2002, POCA, as Colette mentioned, because of that, I think the breadth of criminality that's brought into money laundering already is actually exceptionally broad in the UK. So I think that in all likelihood, that change is less likely to have a severe impact in the UK. Something that I think will actually have an impact, particularly for the regulated sector, is the new offences of aiding and abetting. I think that those are essentially formulated in mind with targeting anybody who is assisting or facilitating money laundering to happen. So I think that it's definitely worthwhile watching how those are defined and how those are transposed into UK law, because I think the aim for that is to try to make sure that anybody who's in any way facilitating money laundering is potentially convictable of an offence. The next thing to mention is the extension of legal liability to legal persons, so criminal liability to legal persons. Now, obviously, that is actually quite an impactful change, and potentially from the impact it will have on companies, partnerships, etc. That could be quite broad. But what I would say is that may not necessarily change the way that a firm complies, but it does potentially raise the stakes. So that's worth noting for that. Finally, and this is along a similar line, the other significant change is that the maximum penalty set in the fifth money laundering directive and previous directives is 1 year imprisonment. In the sixth money laundering directive in December 2020, that will be raised to 4 years. So again, that might not necessarily change the way a firm complies, but again, it does potentially raise the stakes. So with that in mind, I just wanted to flag that help is available for you and your firms to comply. We have our stand in the main hall, and I think we still have a bit of time for Q&A, so I think I'll, at that point, hand back to Clive, if that's okay.
Well, thank you very much indeed.
Thank you.
Thank you. Now, ladies and gentlemen, it is quite a large hall, so it's difficult to get microphones, individual ones, to you in your seats. So there are mics, and they're numbered at the edge of the rows there, and there are two along there. So if you've got a question, please make it down to the microphone. So, questions for our panel, please. Gentleman down here. Thank you very much. There's a microphone's just coming to you now, sir. There you go, other side, there you go.
Hi, if you're acting in a matter and it's not a transactional matter, so you're not caught by the ordinary due diligence that you have to deal with. So a client is asked to send some monies on account to undertake some work, and this is a real example, and they've asked to send £30,000 and they've purported to accidentally send £300,000. Can you send the balance back, please? So you've done no due diligence as you ordinarily would on a property transaction. Now, that was reported to the National Crime Agency, but where do firms sit in that scenario in terms of obtaining due diligence and maintaining due diligence after that?
Zoe, can I bring Zoe in on here, because you haven't spoken yet so far on this. What are your thoughts on that?
Well, I think actually the new standards and regulations will help with that, because there will be a requirement in there to know who your client is. So that will extend beyond the regulated sector. And I think in the particular example, you said you did submit a suspicious activity report, or maybe a defence against money laundering report to pay that money back. I think it has to be, it's really tricky. You have to limit when you hand out your client account details, which, as we know, sometimes even when you're being as careful as possible, these situations still happen. I think a lot of firms will apply standard checks regardless of whether they're in the regulated sector or not, and that's good practice. You might have the information you need. And I think in that situation, due to the volume of money, you would want to do further checks and ask them about where that money came from.
I mean, that's helpful. I think there's quite a drive and determination to streamline processes, because you'll sometimes be asking clients across the range of a business for certified ID, a client then going off and getting that done. Yep. The other firm that's done this sort of work for me didn't ask for that. Why are you asking for it? So it's more about the practicalities of that, wanting to have slick and proportionate measures in place. But this has always been a grey area from my experience, because whilst you take a view that certain work types aren't high risk, that risk will always exist so long as you have a client account.
Yeah.
Yeah. I think
suppose-
that is the best approach, really, for that very reason, because the Proceeds of Crime Act, POCA, catches everybody, and there is a risk there that you'll be committing a criminal offence, and that's massive. So I think that is the better approach, to apply some form of customer due diligence across the board. And then I think it is a case of having some sort of form or policy as you're onboarding that will identify where that risk is, and that's where your client matter risk assessment should really help there and highlight what other documents you might need.
That's my view too, thank you.
Thank you.
Great, thanks very much indeed. Another question, please. There's a gentleman here. So, can we get a microphone to him? Yes, I think we can. You don't have to get out of your seat, thankfully. Pass the parcel. Lovely. And if you could just give us your name and the firm you're from, actually, sir, that would be great.
Yes, Nick Helam, Sydney Mitchell. Just carrying forward on the points you've made, as discussion I've had with colleagues already, the new requirement to identify the client. As those of us in ML know, there's a world of difference between identification and verification. Which is it?
So in terms of our new standards and regulations, the requirement across the board for clients is to identify. It doesn't go as far as verification. So it isn't an equivalent standard to that set out within the money laundering regulations. We're quite clear that that still remains just for work within scope of the money laundering regulations. And I understand we will be publishing some guidance shortly on sort of the wider requirement that's set out in our standards and regulations about identifying a client.
Thank you.
Another question, please, from the floor for our panel. Gentleman at the front here. Thank you very much.
Hi, David Vaughan Birch, Myers & Co. What's the best way to deal with cash? My firm deals in a high cash intensive part of Stoke-on-Trent, principally relevant to relatively low value conveyancing, but also probate and farming brings it into consideration fairly frequently. How do we deal with that?
Interesting, Mark.
I think that cash, and in some ways we don't want to kind of use gross terms that, you know, cash is this or something else is that. You know, everything's a risk-based approach you need to kind of consider on a case-by-case basis. But I think cash certainly falls into that bracket of higher risk. And in that way, one of the ways you can kind of look into why cash is being used is to actually examine potentially source of funds and potentially also source of wealth. So to understand actually why does this person have this money, and to understand the account that they give to you, does that make sense in the verifiable documents they might be able to submit to you in terms of bank statements and the like? Is it expectable in terms of their explanation as to why it's a cash transaction? Is it explainable in terms of the overall picture you can understand of their finances? Is it a gift from somebody? Is it from a transaction? Is it a part of their normal business? Things like that. Ultimately, a lot of the regulations are there to help you protect your business. So it's essentially a question for yourself to try to satisfy yourself that you understand, why is this transaction happening? Why is it happening the way it's happening? So I think looking at source of wealth and source of funds are probably the two most direct areas you could use to address that.
I think just to add to that, actually, it's something that it sounds like is common for your firm, and if that is something that you're doing, I think we'd probably expect it to be set out in your policies, procedures, and controls, just to be really clear about these are the situations in which we'll accept cash payments, perhaps set a limit, and perhaps set out different mitigations for different scenarios. So if it's between X and Y amount, you need to get sign-off from these individuals. Just that you're absolutely clear, and that customers are absolutely clear on what your policy is in accepting cash payments.
I think it's worth noting that just because something's high risk doesn't mean you can't do it. So I think as long as you identify it as high risk, as we have in our sectoral risk assessment, I think that's a problem across the board, like Colette mentioned about PEPs. You know, it doesn't mean a blocker that you can't, in this situation, accept cash, and there may be really good reasons behind that because of their nature of the business. It just might be trickier in terms of the checks that you do to verify that.
Great. Okay. Another question? There's a gentleman over there in the middle. Lovely, thank you.
Hi there, Emesis Saba from Brian Cave, Leighton Paisner. My question is in relation to the economic crime plan. One of the things that especially the banks are looking at doing more with the government is exploring the provision for pre-suspicion sharing of information. And I was wondering if the panel had any views as to whether they saw that as a good idea or something that causes them concern.
Thanks, Emesis. Emesis is sitting on the panel this afternoon, so if you want to be thinking of some difficult questions to ask him, you've got maybe 3 or 4 hours to do so.
You've been rumbled, fella.
I think information sharing is really important. It's something we do a lot. I think the area of pre-suspicion is really challenging, both legally and practically. It's something that I think is in its very early stages of development. It's not something we do at the moment, and I think we would look really carefully at any proposals surrounding pre-information suspicion. So I think there's a lot of work to be done before it becomes a reality, is my opinion.
Okay, one final question, and someone at the back there. Thanks very much.
Hi. Shabul Haq, Westgate Solicitors. Thank you all for the valuable information. My question is that you have mentioned that we would be required to report discrepancies to Companies House. Would you please give us some examples of some of the potential discrepancies that would be required to report, please?
Just to, I guess, give a hypothetical that potentially if you're onboarding a client that is a legal person, in itself a company, and some of the information they submit to you, for example, its board of directors, to take an example, it lists 5 names, and they're certain names, Mr. A, Mrs. B, and so on, that if that information, if that list of names, or even the number of people within that list, differed from what you then actually see at Companies House, then that's where the duty kicks in. That's where you would report the discrepancy, saying, well, actually, I've had this conversation with this company, and the information they provided was this. The information at Companies House, as you can see, is this. Therein is the discrepancy. So it's essentially your duty to report the discrepancy. It's not necessarily your duty to address the discrepancy. However, that the fact that a discrepancy potentially exists might be a consideration for yourself and your firm as to whether that suggests any broader risks around the client itself.
Okay, and one question down there.
Oh, sorry.
Sorry, you're handing it back, actually. Yes.
It was just a follow-up on that one. One of the big challenges that we're going to have with that piece of the law is that we are obliged to find ultimate beneficial owner information. The corporate register is PSC information, of which we are not obliged to check. So I think we need to work out how best we're going to manage that challenge, because the information on the PSC register may not match your UBO information, but that doesn't mean it's wrong or that there's a discrepancy. So I think that's one which will need to be managed very carefully in guidance.
Right.
Yep, agreed.
All right. Okay. 23 minutes past 12. I think we're going to leave it there. Zoe Ellen Robinson, Colette Best, and Mark Boyle. Thank you very much indeed. And thank you for your questions, ladies and gentlemen. Thank you. Right. It's lunchtime, you'll be pleased to hear. And the next sessions, I think, are going to begin again at 1:45, around about then. Yes, so we'll see you later. Thank you.